friends. Today is the final session of the 100-hour intensive online coaching, and today we have amongst us advocate from Supreme Court, our brother advocate Mr. Balaji sir, advocate on record, who has been taking us through the provisions of Indian Evidence Act, and today he will be taking the final session on the Indian Evidence Act. We should thank all who have been connected with this Legal Eagles Elites team taking us through all the sessions. It is not only Adilakshmi Lokamurthy, who everybody knows is the brainchild, but there are so many people who have burnt enough of their midnight oil. I should recognize every one of them. June 14th, we started this free law webinar series, and during the process, we found out that the call for had come. They are trying to find out correct place where they could get the ideas for the examination, or rather the correct faculties to get to brush their topics as such. So we started 100 hours intensive program, and in fact we initially, many told me it is very difficult to cover 100 hours as such. We started that in September 23rd, and very short time. Even if you have one session per day, it is not possible for you. Then I brought in a little innovation of having 2 sessions and later 3 sessions in a day, and we could cross that 100 hours last week itself, and we are now into 130th hour. That is the final session going to be taken by Balaji sir. And many were asking me whether this is going to be the final class of the Legal Eagles Elite. Definitely not. This Legal Eagles Elite is going to travel with you for a very, very long time to come. Only the structure or the topic will be little different, but law will be the base for every other topic. For that is an advocacy programs on the Transgender Act for all the lawyers and law students. It is open for all. It is totally sponsored by Sri Raksha and Voluntary Health Service. So it is a program. I welcome every one of you. So Legal Eagles Elite will be connected with you in one form or other. Before I ask her to continue, may I take the opportunity to thank all the participants who have been part of this great session. I cannot mention certain names because they do not want to tell outside that they have been doing certain work, because they thought it will be fine. They keep their names silent. Even in spite of the request, many wanted to keep themselves silent and quiet. They are the silent warriors. Even one of the faculty is a silent warrior who doesn't tell his name out. Only his voice we have heard. We have, including me, we have not heard about his name or the face. That is the kind of work some silent warriors have done to this legal fraternity, not only in my forum, many forums apart from Legal Eagles Elite, many were like that. So I thank the participants, the volunteers, and above all the faculties. And today we have a special faculty, and along with him there are so many faculties. I'll just give thank you for all the faculties. Honorable Pandavam, Additional District Judge, and Mr. Shankar Murli sir from Kochi, Srinivasa Raghavan sir from Madurai, Paneer Selvam sir, Deputy Director of Prosecution, Swaminathan sir from Mannarpudi, Siva Surya Narayanan, Tirunelveli Bar President, Special Government Leader, HRMC, Mr. Karthikeyan, Muthuvelu sir, and of course our Balaji sir, and Ramesh Ganapati sir, Rajan sir, Senior Advocate Rajan sir, and our great friend Mukund sir, and the faculty of Soil, Vijay Lakshmi madam, and my dear friend Karpagam, my dear sister Karpaga Priya, and Karpusami Pandian from Madurai, and of course my dear beloved Pratap. And he's not the last person I'm mentioning. He, in fact, Mr. Pratap only took us through many of the sessions. In fact, Pratap took the maximum sessions. Sir, I'm mentioning the name of only the 100 hours faculties we have already had sessions taken by other faculty, honorable judges. They took us through the sessions from the beginning in June. So I am mentioning only the 100 hours. Apart from that, during the sessions we had honorable judge, district judge Ravi Raja sir, Satyamurthy sir, honorable judge Satyamurthy sir, and so honorable DJ Karthikeyan sir, and many of the senior faculties had been there throughout the session. But this 100 hours is too special because it was like a 2020 cricket match for me. And of course, I spent so much of time involved in it, but it was all fruitful. I did see some not so good moments also, but I all took it in my stride. It was a very good learning experience. I hope it is very good for you also too. Sir, this is your stage and you are the special guest not only for this session, for the valedictory also. So we invite you to be the special guest to give us this valedictory address at the end of the session after your talk. I thank and I welcome each and every one of you for this session. Thank you so much, sir. I welcome you, sir, on behalf of Legal Invisalign and all the participants who have joined in. Welcome, sir.
Thank you so much for your very valuable speech, madam. Thank you so much for your valuable program also, that you are enlightening so many advocates for the purpose of their career as well as for the examination. What I could recollect from your word is that எழுத்து அறிவித்தவனே இறைவன் ஆவான் அப்படின்னு வள்ளுவனுடைய குரல். It's just hitting in my mind. It's a very beautiful program that you have conducted, that too in this the lockdown period as well as in the pandemic period, where everyone has been confined within the four walls of this house or in the room. So this very no words and nothing could be said, and it's a very fabulous program that you have conducted, madam, that you deserve all sort of appreciation for your spirit and sprite, and it's no words can express that. I too wondered about your continuous spirit and seeing that the message you are floating, and apart from your commitment to your family and your commitment to your doctor, your husband, your doctor, it's very immensely I'm happy about the program that you have started, madam. I'm so thankful for that. On behalf of the society, I'll have to thank. Then for other than that, I have the opportunity you have provided for us to share our knowledge with others also. It's very immense. It has to be deserves appreciation, all sort of appreciations. I really wonder about this program, madam, and thank you so much, madam.
Thank you, sir. Thank you. Sir, a word, this credit should go to me, my beloved father who trained me. My father is a real religious father. He's an advocate. He is Mr. Soundaraj. The first credit goes to my father, and again the credit goes to my mother-in-law. But I lost her during the process of this law webinar. Tomorrow we have a puja for her. That's why otherwise we could have had one more session tomorrow in a different form. And I should thank my beloved, most respected senior, Mr. V.K. Muthusamy sir, the designated senior counsel who trained me as a lawyer, and of course my beloved brother and senior, Honorable Justice M.M. Sundaresh sir, who trained me in so many aspects of law, and great credit to my senior. Even today, I am so proud to call myself to be part of that great office. The 119 law chambers of the Madras High Court campus had produced so many people. Advocate Veera Kadravan sir from Madurai was along with me, Honorable Justice Bharatidasan sir, and the attorney who is practicing in UK, Mr. Shivapunyam, and the district judge Babu sir, all were part of my team. That I should thank every one of them who had been giving me all this strength and support. All this is because of the office where I have been trained. So the credit goes to my office. I'll take a little credit for all my work. Thank you, sir.
Thank you so much. I hope that I can start my session now. This is we are commencing the fourth part of the Indian Evidence Act. We already concluded 3 parts, where we have concluded up to estoppel, and we were about to start last time the witnesses and the examination of the witnesses, which are the last two chapters in the Indian Evidence Act. That is chapter number 9 and chapter number 10. These are the two chapters where we will have to study about that witnesses and the examination of the witnesses. The Indian Evidence Act stipulates who are all the persons who could be competent as a witness. So that commences from section 118. It goes up to 134. How many number of witnesses will be required for the purpose of proving a fact? For proof of a fact, how many numbers of witnesses are required? That is ending in 134. The 35 commences examination of the witnesses. Then the order of examination is commenced from there, and it goes up to 167. It's no new trial for something new admission, which is that concludes in the section 167. So 135 to 167 examination of the witnesses, 118 to 134 are the persons who are competent to be a witness before the court of law. So this was the 118. This is how the 118 starts. We will just go through the. I hope that you all must be having Indian Evidence Act, and apart from that, I will also share the documents which I have prepared. And first, I will simply narrate the section, and then we will come back to the section and along with the case laws, which is so important for us. The 118 speaks of the competency of the witness. Who are the persons who are competent to testify before the court of law? I think that I can share the document. I will just first I will give a narration about that. Then I will come back, and again with my chart I will. Is the document is visible? Yeah. It's running very slow. Document could not be scrolled very fast, so I am just pulling that to 118. Just bear with me for a moment, please. Yes, Chopil 117, under who may testify. Here comes that who may testify. All the persons, please see the wordings here. All the persons shall be competent to testify unless the court considers that they are prevented from understanding the question put to them and from giving the rational answers to those questions by the tender age, extreme old age, disease of whether body or mind, or any other cause of the same kind. Explanation: lunatic is not an incompetent to testify. He is competent to testify provided he is able to understand the question that's been put forth to him and able to answer, and able to give rational answers for it. So this gives these two important criteria. If you could see in this 118, is the understanding of the question, number one, and giving a rational answer to that. These are the two important criteria that's been stipulated in this section. So a witness, to be a competent witness, they have to understand what is a question that has been posed to them and what is the answer, whether the answer which they are giving is a rational answer or not. So this 118 includes a child witness, includes other witnesses who are competent to testify before the court, and other witnesses who could be any witness. Any witness is presumed to be the independent witness and presumed to be the genuine witness first, unless otherwise the contrary is proved, unless he is not reliable or the credit is in peace. So this is how we'll have to construe and see this section 118, which includes a child witness also. So in general, all the persons who have been above the age of 13 has been termed as a witnesses who are competent to testify. in order to be a witness, what are the things to be adhered to? For the purpose of to be a witness, for the purpose to be a witness before the court of law, we have to adhere to the Oath Act. Well, initially I have taken the Oath Act about that, what are the provisions of the Oath Act and what are the mandates that's been provided with the Oath Act. And once you are going to the court as a witness, you will be asked to say that what all the things I am saying is true and nothing but true. And this is what it may be on some the religious book, and we will have to swear on the religious book and swear on the God that what I am saying, what I am deposing before the court is only true and nothing but true. This is what the promise which will be taken from the court master. So this is where it is stated here in Evidence Act. This is not at all stated in Evidence Act, but it is as per the Oath Act. So just for the recollection, we are now dwelling into the Oath Act for the purpose of recollecting what we initially in the first part we have stated. I have narrated about that Oath Act's commitment and the obligation of the witness. A person to be a competent witness. Oath Act section 4 specifies, earlier it was Oath Act 1878 or 73 something. Then it was repealed in the year 1969, and this repealed act, very small act it is, it mandates that oath has to be administered to the persons who are giving oath. This is as per the section 4 of the Oath Act. So the persons who are willing to administer oath before the court of law, and any person who is going to be an interpreter of any questions put to and the evidence given by the witness, and any persons who is coming under the ambit of jurors. Earlier it was jurors. Now at present there is no juror. There is no that's being taken away. It was during the British period. All the three persons are must and mandate to be administered with the oath as per section 4 of the Evidence Act. I will read the section 4 of the Evidence Act for your convenience, just for understanding. Oath or affirmation shall be made by the following persons, namely all the witnesses, that is to say all the persons who may lawfully be examined or give or be required to give evidence by or before any court, or the person having the law or consent of the parties authority to examine such persons and to receive the evidence. So the witness is coming within the ambit of section 4. So if you come to the proviso to that, provided where the witness is of child and where it is of age, under age of 12 years of age, the court or the person having authority to examine such witness is of the opinion that the witness understands the duty of speaking the truth before the court, but does not understand the nature of the oath. What is the purpose of the administration of the oath before the court? If that nature she or he could not, the child could not understand, then in that case the application of the section that the witness shall be administered with the oath is exempted. That shall not apply. That's what the proviso exempts. What the proviso exempts, once again I will say, the proviso exempts the children up to the age of 12 years who could understand the duty to speak before the court, but they may not be able to understand the nature of the oath. What is the nature for which the oath is being administered? So if that nature could not be understood, then if the duty of speaking truth could be understood by the child, that child is exempted from giving oath, exempted from administration of the oath, provided that the age should be below 12 years. This is what the exemption that is provided under section 4 of the Oath Act. Then section 8 of the Oath Act, the mandates every person who is giving, I am reading it, then I will give a narration. Every person giving evidence on any subject before any court or a person hereby authorized to administer oath and affirmation shall be bound to state the truth of the subject. Shall be bound to state the truth of the subject. Any person who is willing to give an evidence before the court is bound to state the truth of the subject. This is what the mandate that's being given under section 8 of the Oath Act. So, if the oath has not been administered, what would be the consequence and effect? That will be the question that will be striking in our mind. Immediately after reading this section and reading the section along with this 8 along with the section 4, what would be the contraventions of this? If you are not saying the truth before the court of law under section 8 of this Oath Act, you will be liable for perjury. Under section 8, if you are not going to say truth and if your statement is going to be falsified, you will be liable for perjury. That's what the 8 is. 8 does not speak about the perjury. That will be under the Indian Penal Code. But what 8 mandates is you are bound to speak the truth before the court. That's it. Then, in case if the oath has not been administered, what would be the consequence? That's what the 7 says. 7 of the Oath Act says, in case the oath has not been administered and some error in the administration of the oath, some error has been there in the administration, some irregularity is there in the administration of the oath, that will not render the proceedings invalid, that will not render the proceedings invalid, and also will not make the evidence also inadmissible. As because oath has not been administered to a particular witness, it does not mean that the whole witness is inadmissible, and it does not mean the whole proceedings is also invalidated because of this non-administration of the oath, or because of some irregularity in the administration of the oath. That's what the section 7 gives a protection for non-administration of the oath, as well as for any sort of irregularity or any sort of omissions in the oath act. So this 7 and 8 as well as 4 has been very much dealt with in the 1952 Rameshwar case, which I already have said. The Rameshwar case, 1952 ARSC, page number 54, I think. And if you could see the Rameshwar case, that was a child rape case, where the child will be the witness before the court, as well as her mother also will be a witness before the court, and whether the issue will be whether the child witness is always required to be corroborated or not will be the prime issue. We will deal with the issue later, primarily, and I will come up. Will deal with the chart. I will deal with that case, and this is what has been dealt in the Rameshwar case. If you want to compare, always when you go to 118 of the Evidence Act, you have to compare that with the Oaths Act and the competency pertaining to the deposing before the court of law, testifying before the court of law. This has been elaborately dealt with this case, the Rameshwar case. And then we will come to the section 118. What are the mandates? The mandate would be that putting a question, understanding the question, and giving the rational answer. If suppose the answer is not going to be rational, and suppose the answer elicited is not given in accordance with the question that's been given, it is now connected to the question that's been given to the put to the witness, then the court can come to the conclusion that there no rational answer have been given. So therefore, the competency could be decided by the court of law. That's what the comparison. On the comparison, in the Rameshwar case, they will deal with. There are two aspects as far as if you take into consideration of the 118 of the Evidence Act is concerned. One is pertaining to the competency. Next one is pertaining to the credibility. Suppose, I will repeat once again. First one is pertaining to the competency, as is what stipulated in the 118, and second one is pertaining to the credibility. So, if the oath has not been administered, it will not get into the competency at all. Only it will go to the credibility. It is the second part. So the court will come to the conclusion on the basis of that, the answer that's been evolved, or on appreciation of the evidence, or during the evaluation of the evidence, they will come to the conclusion this person is not competent to testify. That could be done during the credibility. Initially, once it is the omission has been done, the person has not been administered with the court of oath. So for this reason, you cannot turn in the appeal or in the later stage of argument, as because the oath has not been administered with the child or with the person who is deposing before the court, it is inadmissible. You cannot argue. You can argue only on the credibility of this matter. That's what has been the discussion in the Rameshwar case. I'll now narrate that Rameshwar case. There's a child about 8 years age will be raped by the accused. She will come to the home and mother will not be there. Mother would have gone to some agriculture work and she will return back after 4 hours. The moment the mother comes home, she will weep and say that I have been raped by this is what has been done by the child. This is what has been done by the accused. So this is a statement which is given to the mother immediately after the occurrence. So this, on the basis of this statement, the mother will go and give a complaint to the police that this is what has been done and offence has been committed, and ultimately the mother and child both will come and depose before the court of law. In the court of law, first child will depose that immediately after the occurrence, I disclosed everything to my mother, what has happened. This is the one statement which was given out of the court. This is a statement which is given to the mother. The mother also will depose before the court that my child said, my daughter came and said, when I returned to my home, this is what has happened. So, there are two segments. One is child saying to the mother immediately after the occurrence. Second one is the mother deposing before the court of law. So, whether the same thing has been deposed by the child also as a prosecution witness. The child deposition is whether required to be corroborated, is corroborated by the mother. If corroborated, whether it could be termed as an independent corroboration. That's what the prime issue that's been dealt with in Rameshwar case. See, the child witness is always, in general, child witness will be prone for tutoring. Child will say whatever has been said by somebody else, whatever been said by the person under whose influence the child lives, will be influenced by the words of the person, and every tutoring, every possibility for the tutoring. Therefore, they settled the proposition of law as far as the child witness is concerned. Child witness should be dealt with caution, with care and caution. As a matter of prudence, as a matter of caution, it is not as a matter of evidence and matter of practice. It is as a matter of prudence and it's a matter of caution. Child witness always we should look for the corroboration from the independent source. It should have some corroboration from the independent source. That's what the general settled proposition of law. But in this Rameshwar case, it was dealt whether the mother's deposition before the court can be taken as a corroboration to the testimony of the child. Then the answer was given is positive. Positive, saying that in affirmative it was said that it could be taken, the mother's deposition before the court of law, it could be taken as a corroborative piece of evidence to corroborate, though it is substantive, it corroborates, it's also mother's speech is also a substantive, it corroborates the testimony of the PW2, I think the child is corroborated with the mother's testimony. Here, corroboration is required for the purpose of strengthening the case. That's what ultimately the court will say. In all the cases, it is not required that it has to be corroborated. There could be some exemptions also. In general, it needs to be corroborated. There could be some exemptions where the child is completely reliable, cogent, consistent, clear, reliable, inspires the confidence of the court. If that is the case, no corroboration is required. In all the cases, corroboration is not required. If it does not inspire the confidence of the court, if there is some inconsistencies in the deposition of the victim or the child, then the court may look for the corroboration from the independent sources. In this Rameshwar case, which is not in 1952, written by Honorable Justice Vivian Bose, he said that it could be taken as the mother's testimony could be taken as the independent corroborative testimony for the purpose of strengthening the child's testimony, and the conviction was upheld in this case in 1952. This is by the Supreme Court. This AR 1952 ARSC page number 52. It's a very detailed discussion case. Please go through that. And there was an argument that was raised. If I go detail into this case, it will consume a lot of time. There will be an argument that will be raised in the court that saying that on the basis of the single sole witness, the conviction cannot be affected. Conviction cannot be affected on the basis of the single witness. The court also will deal with section 134. We will deal with 134 later. Court will also deal with the 134, saying that no particular number of witnesses is required for the purpose of proving a fact. One single witness. It is only the quality. It is not the quantity. It is only the quality which will matters. It is not the quantity that is matter as per section 134 of the Evidence Act. Therefore, single witness which can inspire the confidence of this. This is also dealt with in Vadivel Devar versus State later in 1957, I think. We will come to that case also. And single witness, only this, the evidence is only weighed here. It is not counted. It is not the counting of number of witnesses. The court will not go by the number of witnesses who are present, the number of witnesses who are deposing before the court. The court will go by only the weight of the evidence. It is weighed before the court of law. This is This is declared in Ghulam Sarbar case. Ghulam Sarbar case, that's also in later 1960 something. And you can go through these three important cases, Rameshwar, Ghulam Sarbar and Vadivel Tevar case, for the purpose of this, the competency of the testimony. And this is what the 118. I think that we can go to 119 next one. 118 I can say a lot of cases. For the child witness, you can go from Rameshwar. You can write Panchi, Panchhi, Panchi, then Ashok Dikshit, and very recently Digambar Vaishnav, that's been rendered by Supreme Court, Digambar Vaishnav. Then Alagu Pandian, a case called Alagu Pandian, you can take Alagu Pandian alias Alagu Pandian, that's also by Supreme Court. So there were a number of judgments that's been given as far as the child witness is concerned, but in general they will say that it needs to be corroborated, but there are certain exceptional cases where it could be exempted from. And one another case for child witness, you can read Om Prakash versus State also. Om Prakash. I'll say that Rameshwar, Digambar, Panchi, Ashok Dikshit, Alagu Pandian, Om Prakash. All these 5-6 cases you can go for this child witness, which is elaborately it has been discussed. Then we'll come to 119, which is deaf and dumb witness. Deaf and dumb witness, how it has to be termed and how it has to be, the evidence has to be evidentiary. What is the evidentiary value of the dumb and deaf witness? Here, I'll read that provision here. You have a witness who is unable to speak may give his evidence in any other manner in which he can make it intelligible. He can make it intelligible by means of the writing and signs. But the writing and signs must be made in the open court. Evidence so given shall be deemed to be oral evidence. See, the evidence shall be deemed to be oral evidence, number one. There is no bar for the deaf and dumb witness. They can speak, they cannot speak, they can express it, they can by sign or by writing they can say it, and they can make it in such a manner, make it in intelligible manner, whatever it means it may be. It's an intelligible manner, they have to express it. This is what the dumb and deaf witness says. And once they depose before the court, though it is sign and writing given by some interpreter or somebody by an educator. In the proviso, if you can see, the proviso is here missing. The court can also make use of an interpreter. The court can make use of the educator who understand the language of the deaf and dumb. So their services could be utilized for the purpose of what is the real conveyance by the real what the child witness really conveys to the court of law. Deaf and dumb witness conveys to the court of law. For that purpose, educator could be appointed or an interpreter could be appointed for that purpose. But they are not termed as an incompetent witness. They may give evidence in any manner in which they can make it intelligible by writing or by sign, by means of the gesture. They can give it. So for this dumb witness, I'll give two cases. This one is Srirangan by Honorable High Court of Madras. One is Srirangan. Another one is Pandian versus State. As far as the Srirangan is concerned, here also the child would be raped. The child is of dumb and deaf. I think that's a neighbor who's was committed that crime, and she is a dumb and deaf. If you go through the judgment, she will clearly express that what has been done by means of the gestures. That gesture has been believed by the court and believed by the trial court and believed by the High Court as well. And it's a case of POCSO, I think, and ultimately it will land up in conviction. This is what has been happened in this, but this was no corroboration, nothing else. On the basis of the open court, this PW8, the child was PW8 in this case, in the Srirangan case, and in the open court, she will give, by means of the gesture, she will make the judge to understand what really happened during the commission of the crime. So that clearly proved that amounts to a oral evidence before the court, that amounts to a substantive evidence before the court of law, that amounts to an oral evidence also before the court of law, on the basis of which the conviction was effected. Here, the next case, this case is Srirangan versus State. Is Honorable High Court of Madras. This judgment was rendered by Honorable Justice S. Nagamuthu, and the second one also by the same judge, and Pandian. He see the difference between, because I have taken these two cases for this to give a different impression that's been evaluation or appreciation that's been taken by the court. Here, the dem and def was completely believed. Next one is Pandian is a husband. He will commit murder of his wife, who is a dem and def. That dem and def being brought up by the mother and brother, that dem and def's language is understandable to the brother and mother, that is PW1 and PW2. And she will immediately after the occurrence, I think this is a burning by kerosene and pouring, setting fire, I think. Then after that, she will be taken to the hospital. During the hospital and course of the travel, she will say that my husband has committed this crime, and this gesture has been, she has expressed it by means of the gesture. This, what she expressed by means of the gesture to the PW1 and 2 is deposed before the court of law by the PW1 and 2. They will depose that this is what is the gesture that's been given, so this amounts to a dying declaration. What is the fallacy is, but the court is not inclined to believe that the PW1 statement and PW2's deposition, PW1's deposition and PW2's deposition, one is a mother, one is a brother, deposition was not believed, saying that no, there are certain discrepancies in the circumstances which gives a doubt pertaining to the declaration that's been given by the deceased. It amounts to whatever the gesture and other the signs and this indication that's been given by this deceased would amount to dying declaration. So that's what has been made, the prosecution made an attempt to establish that by means of the PW1 and PW2. But thing is that the doctor who examined that lady, the deceased, was not at all examined before the court of law. The medical records which was given to her during the time of the treatment, which were created during the time of the treatment in the hospital, were not produced as exhibits before the court of law. No attempt has been made to get a dying declaration through a doctor or through a magistrate. Why the magistrate was not called, that was also not explained by the prosecution. So therefore all these things had been taken into consideration. Ultimately the court said that PW1 and PW2's evidence is insufficient to hold that the accused is committed, and the accused will be acquitted, and the criminal appeal will be allowed. This also by the same court and the same judge, and this is what the two difference I can give as far as the dem and def witness is concerned. One is Srirangan, second one is Pandian versus State. These are the two things. All are available in India Qanun and in the internet. Once you put this honorable judge's name and Srirangan versus State, you will get the judgment. And as well as the Pandian and the judge's name, and the deceased name is Tamilchelvi here. Pandian, the deceased wife name is Tamilchelvi. So these are the two best examples that I can give as far as 119 is concerned. And this also, we can also say that these two things, we will, when dealing with the section 157 of the Evidence Act, we will come to that. This the statement which is given by the deceased to the PW1 and the PW2, the brother, and also in the first Rameshwar case, the statement given by the child to the mother is a statement which were given at or about the time when the incident has happened. If it is given at or about the time the incident has happened, that becomes a corroborative piece of evidence which will tend to corroborate the later testimony as to the same fact in the court. That's what the 157 speaks, and we will come to that. That the Rameshwar case will deal with that also, whether the statement is at or about statement which have been given at the time when the incident has happened. So that also will be dealt with in the Rameshwar case, and we will deal with that elaborately once we come to the 157 Evidence Act. This is dem and def witness I completed. Next one is 120. 120 is with respect to the husband and wife. It's very simple to understand. It's not required a detailed discussion as that of the period 119 and 118. 120 is, as far as the civil case is concerned, the husband and wives could be a party, and they can be I'll read it. In the civil proceedings, the parties to the suit. In all civil proceedings, the parties to the suit, the husband and wife of any party to the suit shall be a competent witness. In criminal, vice versa. But in criminal proceedings, against any person, only against any person, not in favor of the person, against any person of the husband or the wife of such person respectively shall be a competent person. The husband can, in criminal proceedings, in civil proceedings, if wife files a complaint, wife files a plaint, husband could be a witness for it. Husband could be a witness for it. In the criminal case, in contrary to that, in criminal case, against a person, husband or wife, yeah, husband or wife could be a competent person. If a wife is a complainant, husband could be a competent person to be a witness. And if the wife files a complaint, husband could be a competent against her, for deposing against. So here, please understand this word here, proceeding, the criminal proceedings against any person. This any person, in the any person, against any person, you have to put the husband or wife. So against the husband or wife, the vice versa person will be, the other side will be the competent person to be a competent witness. This is what has been explained. I hope that you could understand it. In the criminal proceedings against a wife, husband could be a competent witness. In the civil proceedings, in favor of the wife, husband could be the competent witness. This is what is the simple meaning, I can say that. So then comes the judges 121. This will be important. Some question will, since you are writing the examination for the district judge, some importance will be attached to this section 121. I searched for some judgment, but I also dealt with one case where, but it is not before the judge. It is Murugan versus State. That is the judgment was rendered by Honorable Justice Ranjan Gogoi and Justice Sadasivam by the Supreme Court. This happened in Thoothukudi district. It's a triple matter case which will happen before, not in the court, inside the court hall, but not before the eyes of the judge. She will be in chamber. She or he or that magistrate will be in chamber. I'll tell you the narration about the facts of the case. You can compare it with that. But here, no judge shall, no judge. What this section 121 mandates is, judge and the magistrate. No judge or the magistrate shall, except upon the special order of some court to which he is subordinate, be compelled to answer any question as to his, which came to his contact, as to his contact, or came to his knowledge during the course of his proceedings. I'll read it once again. No judge or the magistrate, except upon the special order of some court to which she is subordinate, be compelled to answer any question as to his own conduct in the court, as such as a magistrate or judge, or anything which came to his knowledge in the court, as such judge or magistrate. But he may be examined as to other matters which occurred in his presence while he was so acting. Here, in this Murugesan case, that's what do you call that? The place is some Kulam. I'll just, in the end of that meeting, I'll give you that. Murugesan was a state, if you put Thoothukudi district, then in that case, 3 persons will be coming out on bail. A15's brother will be murdered. So there will be an animosity between the accused group and the deceased group. All the three, D1, D2, D3 will be produced before the court for for protection of some surety and bond once they are released on bail. So therefore, when they were produced before the court, all these accused persons will emerge into the court, and all the 3 persons will be hacked. And also including the PW5 and PW7, both will be the security guard for the purpose of protection. They will be brought from the jail. They also will be attacked, and they will say that we have been attacked by stone. But real injury, that's been, as per the doctor's opinion, they were attacked by Arwal. The injuries were all Arwal injuries. So this is what the main contradiction. Ultimately, this case will end up in the 3 murder case. Ultimately, it will end up in acquittal in the Supreme Court. It's Honorable Justice Ranjan Gogoi and Honorable Justice Sadasivam. This happened inside the court hall, but not before the judge. The judge was not examined he was examined as a witness, but see the difference. It's occurred inside the court hall, even if it occurred in front of the judge. That's why, for the purpose of explaining, I am saying this. The incident has occurred. It's not connected to the proceedings. If anything, see here it says what is cannot be compelled. See this 118 to 131, 32. It speaks about some privileges with some witnesses. the privileged witness. We can also say the privileged witnesses. So here, judge and magistrates are the privileged witnesses who cannot be compelled to come and depose pertaining to anything they had, anything pertaining to their conduct during their proceedings, or anything which came to their knowledge during the proceedings. So, if I suppose I am going to be a judge, I am writing the judgment that these were the appreciation of evidence, and these are the things which I appreciated, and I gave a judgment. I cannot be compelled to disclose on what basis I came to that conclusion. Cannot be compelled. So there is the two things which are privileged here. What are the things privileged here? Number one, compelled to answer as to his own conduct in the court. Cannot be compelled. He cannot be compelled to give any deposition. Number two is anything which came to his knowledge. Second one is anything which came to his knowledge during the course of his proceedings. So these are the two things which cannot be compelled to answer of his own conduct. These are the two things of which the judge or magistrate cannot be compelled, but he can be examined as to what are the other matters which occurred before them while they are so acting. Suppose the murder is committed like this. Judge is sitting in the dais and asking for the surety has been produced. At the time, if the hacking has done, suppose if this has happened and judges also witnessed it, then the magistrate could be compelled to give deposition as to it. I hope that 121 is explained. Then we'll go to, then you can see this illustration also for the better understanding. We'll go to 122, the communication during the marriage. A person who is or has been married no person who has been married shall be compelled to disclose any communication made to him during the marriage by any person to whom he or he has been married. At the time of marriage, what is being communicated by husband to wife or wife to husband shall not be compelled to give testimony about it. So this is coming under the privileged communication, the communication during the marriage. This is very simple to understand. Then I will skip over to 123 of the Evidence Act. Then affairs of the state. No person shall be permitted to give any evidence derived from unpublished public official records, derived from the unpublished records relating to the affairs of the state, except with the permission of the officer at the head of the department concerned, who shall give or withhold such permission as he thinks fit. Here also there is a privilege given to the officer who is controlling the department to give a permission to give the deposition with respect to the unpublished official records pertaining to relating to the affairs of the state. This is the 123. No much explanation is required for this. Then we will skip over to official communication. It's also similar to the affairs of the state. No public officer shall be compelled to disclose the communication made to him in his official confidence. In any official confidence, any communication that's made to the officer shall not be compelled to be disclosed before the court of law, cannot be compelled to be testified before the court of law. This also does not require much explanation. Then we'll go to 125, information as to the commission of the offence. No magistrate or police officer shall be compelled to say that from where he got the information pertaining to the commission of the offence. So this information is also a very privileged information, and it's pertaining to this information no police officer, no magistrate or no revenue officer also. Revenue officer can be compelled to give a information, compelled to give a deposition, testimony pertaining to from where they got from. If you can see that always, if you see that in the case of FIR registered with the CBI, from the reliable information we got that such and such information has been that such offence has been committed, and therefore from this information we register the FIR and we start the preliminary inquiry, and so on. So the other details will be there, but the informant will not be there. The informant will be the first information report will be registered by the police officer himself on the basis of some reliable information. So this is, you can connect it with the section 41 of the CRP also here. The information as to the commission of the offence, if the police officer has a reliable and reliable, reasonable information as to the commission of the offence, he can go and file an FIR and start the investigation. There are 3 or 4 things that will be there. From the information from the reliable source, credible source, or the commission has been committed in front of his eyes, or the information which is provided by some complainant saying that such commission of crime has been happened or committed. On all the basis of this, the FIR could be registered and we can proceed without warrant and he can arrest also. That's 41, section 41 to, I think that up to 60 it goes about saying that the investigator pertaining to the arrest and other things. In the CRPC, these are the fundamental things which are enshrined in that. So this could be connected with the section 41 of the CRPC. Then 125. Then comes the 126. This 125 does not require much explanation. You can simply read and understand it. And I could recollect one of the case which I dealt, in which one of the bar council member was arrested. That member was from, I do not want to disclose any name here. The member was from Tamil Nadu. It was some allegation against some sort of against the three members of the bar council of India. Some information as to the commission of offence had come. The CBI has filed an FIR. FIR simply said, on the reliable information, we registered the first information report. So on the basis of this first information report, we proceed with the investigation. That's it. Nothing more than was written in that first information. When I asked for the bail pertaining to that, the bail was declined. No. So this is how that the first information, the information, the FIR, first information report, is protected under section 125 of the Evidence Act. This is how you have to understand this under 125 of the Evidence Act. Then comes the 126, this professional communication. No barrister, attorney, pleader or vakil shall at any point of time be permitted, unless with the express consent of the client, to disclose any communication made to him in course and for the purpose of his employment as a barrister, pleader, attorney, vakil, or on behalf of his client, and state the contents of the conditions and the documents with which he has become acquainted in course and for the purpose of this professional employment, and to disclose any advice given by him to his client in course of the such course in the course and for the purpose of such employment. See here, my vision is not proper. I think I have to change my glass. The no barrister, attorney, pleader or vakil shall at any point of time be permitted to disclose any communication made to him by his client. That's it. That's simple. Any communication made by a client to the vakil, to me as a vakil, in the course of my professional communication, I cannot be compelled to disclose it before any court of law. I cannot be compelled. So this is a privileged communication between this advocate and his client. See, this you have to read it along with 129. Similarly, client also cannot be compelled. A criminal client comes, he commits a murder. I am conducting the case for him. Police can compel him to ask him and compel him and say, no, you have to depose before the court of law what you have said to what you have said to your advocate. This cannot be compelled. So similarly, under 126, I cannot be compelled what he has disclosed to me in course of my professional employment as a vakil, barrister, attorney, pleader, or so and so, whatever it is. So this is how the privilege. This is called the privileged communication. This professional communication, this 126, and the privileged communication, this 129, both are connected. So this privilege is also applicable to our servants. During the course of the discussion, my junior will be there in my chamber. My clerk will be sitting and typing something else. He also will be hearing what the client says. Sometimes he may have to hear what is the discussion between me and client. Juniors might be there, or some other clerk will be there. My clerk will be doing some other business. So therefore these people who are working with the attorney also cannot be compelled to disclose what that particular client has said in your office. So this is how the 127 applies to the interpreter. No provision of the section. The provision of section 125 shall also apply to the interpreter, clerk or servant, barrister, pleader and vakils. This includes the junior also. So whatever the communication that's been disclosed by the client to the advocate cannot be compelled to be disclosed before the court of law, testified before the court of law. This is how the 127. Then this is not waived because of the voluntariness. This privilege is not waived because of the voluntariness. As I'll go through it. If any part of the suit, in any part, if any party to the suit gives evidence therein at his own instance or otherwise, he shall not be deemed to have consented thereby to such disclosure as is mentioned under section 126, and any party to the suit or proceedings calls any such a barrister, attorney or witness, he shall be deemed to have consented to such disclosure only if he questions such barrister, attorney, vakil, or so there's simply saying that it's not waived by means of the privileges, because I am taking the privilege of it. I say that since it is waived by volunteering the evidence, I am volunteering the evidence, this privilege is not waived. Still, this is a protected communication under the Evidence Act 128 of the Evidence Act. Now we go to 129, the confidential communication with the legal advisors. I already have narrated confidential communication of the client to the advocate cannot be compelled to be disclosed before the court of law. I will read it here. No one shall be compelled to disclose to the court any confidential communication which had taken place between him and his legal professional advisor unless he offers himself as a witness. In such case, he may be compelled to disclose any such communications as may appear to the court necessary to be known in order to explain any evidence which he has given, but no others. So, no one shall be compelled to disclose to the court any confidential communication which has taken place between him and his legal advisors, unless he offers himself as a witness, in which case he may be, if the client himself volunteers, if he offers, no, I will give this, and he may be compelled to disclose such communication. If he offers or volunteers, he may be compelled to disclose such communication as may appear to the court necessary to be known in order to explain any evidence which he has given, but of no others. So, if the court requires certain things to disclose, that could be disclosed on voluntariness by the client, but of no others. Something it's some clutching point is given here, and of no others. This could be applied only, it could be understood only if we apply it practically in some other matters, according to the facts and circumstances of the cases. We not have dealt with such kind of cases, so therefore, but some key is, I could see some key here, but of no others. It's almost like section 5, relevancy, the evidence can be given as to fact and issue and relevant fact, and of no others. Existence of the fact and issue and existence of the relevant fact, and of no others. It excludes the irrelevant facts. This is what some key words have been given here, which have been excluded. Then comes the 130, production of the title deeds, which a witness is not a party. Suppose a witness comes before the court and he is compelled to, he is disclosing about some title deeds, but he is not a party to the court. But when he is not a party to the court, he cannot be compelled to produce the title deeds which he possesses. So unless otherwise he is permitted by the court, or some excuse will be here, exemption will be here. No witness who is, I will just go through the section, please listen to it. No witness who is not a party to the suit shall be compelled to produce his title deeds to any property or any document by virtue of which he holds a property as a pledgee or mortgage. I am the mortgagee of the property. Assume that I am a mortgagee. Or any document the production of which might tend to criminate him, unless he has agreed in writing to produce them with the person seeking the production of such a deeds or the person claiming through them. They are seeking the production. So I am the mortgagee of the property. I gave some money and mortgagor has given some property to me as a mortgagee. I am holding the property. So I cannot be compelled to give evidence, the title deed, deposition of the title deed, unless I am a party to the, say, simple understanding is this. See, there will be a party, there will be a witness in the case. The witness will be holding or possessing some documents. The witness cannot be compelled to produce a title deeds which he is in his possession, which if he produces, it will tend to incriminate him. So these documents cannot be compelled unless otherwise he is a party to the case. Only the party to the case can be compelled to produce a document. Witnesses cannot be compelled to produce a document. This is also some privilege given to the witness. So therefore it comes under the privileged witness. This is 130. Similarly, 131 is also protection of the electronic records, which other persons may have a right to refuse to produce. Those documents also protected privilege. No one shall be compelled to produce any document in his possession or electronic records under his control, which any other person would be entitled to refuse it. So if any person is entitled to refuse any document to be produced before the court, if that document is in my possession, I cannot produce it before the court of law. I am barred under section 131 of the Evidence Act. This is how this sections could be understood. And then comes 132. 132 and 147 are the brothers, like when you are compelled to give a witness. We will have to deal with first 147 under section 147 of the Evidence Act, but the 132 falls in the chapter number 9. 147 falls in the chapter number 10. We will connect both the things and we will take a class on it. I will give an explanation connecting both the things. So therefore now we will go to 133 and 134. So that we will conclude this 132. I will deal with that once I start 147 of the Evidence Act. When the witness is compelled to give a witness evidence, when he is compelled to give a evidence, and 148 is the power of the court to compel a witness to give a evidence, though it may tend to incriminate him or tend to forfeit some of the properties or something like that. So these two, 148, 147 and 132 are interlinked. I will explain it along with the chart which I have prepared. So we will just wait for some more time for the purpose of this coming to this 132. I hope that from 118 to 131 you would have understood completely about each and every section. And now it's 133 we will go. Accomplished witness. This accomplished witness also should be read along with 118. Accomplished is always here. It says what the section stipulates. We will first see that what section stipulates. An accomplished shall be a competent witness against the accused person, and conviction is not illegal merely because it proceeds upon the uncorroborated testimony of the accomplice. I will read it once again. Accomplice shall be a competent witness against the accused person. Accomplice is a competent witness against the accused person, and conviction is not illegal merely because the court proceeds upon the uncorroborated testimony of the accomplice. Simple understanding is an accomplice witness is a competency. It falls under 118 of the Evidence Act, number 1. Now, the court can also proceed on the basis of the uncorroborated testimony of the accomplice. Accomplice could be accomplice is a substantive evidence. He gives a substantive evidence before the court of law. So whether it requires accomplice is always to be treated as a weak and tainted witness. Therefore, in the court of law, the theory of double test has been evolved. Theory of double test. That we will come to the theory of double test. But accomplice, if he inspires the confidence, if it does not create any doubt in the minds of the court, if it is clear, consistent, cogent, and reliable, then the accomplice could be, without any corroboration, could be relied upon, and the conviction could be effected on the basis of accomplished evidence, approver evidence. We can say once they get the pardon under section 306 and 307 of the CRPC, they will become an approver. Then the approver evidence could be completely relied upon. So this is what they accomplished. But if you take that 114 illustration B, then if the accomplice if the court presumes that the accomplice is unworthy of credit, suppose the court presumes, that's the presumption under section 114 the court always can have, pertaining to, please recollect that, pertaining to human conduct, pertaining to the natural course of event, pertaining to the private business, pertaining to the public business. So for all these things, having regard to the facts and circumstances, court may regard that such a fact exists. Court may presume that yes, fact exists. This is a presumption under section 114. Under the 114B, illustration B says, if accomplice is unworthy of credit and it shall be corroborated, the court may look for the corroboration by the from the material particulars. If the court presumes that he is unworthy of credit, then the court may look for the corroboration from independent sources in the material particulars to corroborate the accomplice. Still the accomplice is the substantive evidence. It never becomes a corroborative piece of evidence. But substantive, the accomplice evidence accomplice evidence requires corroboration if the court presumes that he is unworthy of credit. That's how we have to harmonize these two sections, that is 133 and 114b. Please understand, 133 says no corroboration is required. 114 says if presumed to be untrustworthy, then the corroboration is required. Unworthy of trust. If the court presumes that the accomplice is unworthy of trust, this is the exact word, unworthy of trust, then it may look for corroboration from the material particulars. This is the two different, how you are harmonizing it. Here, corroboration is not at all required. It is not unlawful that convicting a person on the basis of the accomplice witness. There, corroboration is required. When corroboration is required, when court presumes that he is unworthy. That's therefore harmonizing both the sections. There were so many case laws that's been evolved. Even very recent case also, I already discussed. I said Deena and Banu's case of Honorable High Court of Madras, rendered by Justice Honorable S. Nagamuthu. Honorable Justice Nagamuthu has rendered the judgment. You can please go through the judgment. He has cited a number of judgments relying upon what is the evidentiary value of the accomplice. Accomplice is always a weak and tainted piece of evidence, having participated in the crime. He participated in the crime. Now he wants to escape from the liability, punishment. Therefore, he now gives the evidence. When the evidence is given, he has to be seen with the tainted vision. He is a tainted man. So therefore, we will have to look for corroboration from the independent sources. Though it is a substantive piece of evidence, always looking for the corroboration is the second. What is the two tests that has to be applied here as far as the accomplice witness is concerned? One is test of reliability, second, which is applicable to all. This first test is applicable to all witnesses. Second one is the test of corroboration from the independent sources. So therefore, in the Banu's case, the Honorable Judge will rely upon the four judgments that's called Sarwan Singh's case, Sarwan Singh, Ramlal Mohanlal, then Ram Narayan and Balwant Kaur. I will tell you the year of the judgment also. Please, if you want, you can just note on this. All people will be in the verge of examination. We will not be able to go through that in detail. Sarwan Singh's in the year 1957. Then Ramlal Mohanlal in the year 1960. Then Tribhuvan in the year 1972. And Ram Narayan in the year 1973. And Balwant Kaur in the year 1988. These are the four judgments which you can go through just to have a glance at it, browse at it, and what is the evidentiary value of the accomplice. It has to be corroborated and it has to pass the double test, that is the test of reliability and test of corroboration. These are the two things that it has to comply with for the purpose of, before getting the weightage and sufficiency for convicting a person on the basis of the accomplice witness. So this is the 133 which I have explained, and 134 is a very interesting one. And no particular number of witnesses shall be in any case be required for the purpose of any fact. No particular number of witnesses is required. Please read this section again and again. No particular number of witnesses, that is, particular number of witnesses shall not be required for the proof of any fact. So the number is not important. Even only one witness will do. Only one witness which inspires the confidence of the court, which is sufficient, and it could be, the weightage could be given to that for the purpose of effecting conviction. This is 134. This 134 has been elaborately dealt with in Vadivel Devar case. It's a case from Nagapattinam district which went up to Supreme Court, and ultimately the witness could be termed into three categories of witnesses. One is, number one, wholly reliable. Any part is not, any part of his witness, any part of the testimony is not liable to be rejected. Whole witness is reliable witness. Second one is whole is irreliable, not reliable. So we cannot completely believe this witness. We cannot, is unworthy of trust. Not even a single word could be relied upon. Completely rejected. Second one is partially reliable, partially not reliable. That is, partially reliable. We can take that it's a partially reliable witness. Certain evidences could be taken. Certain testimony as to certain facts could be taken as is a reliable thing. So therefore, these are the three categories which has been derived by means of this Vadivel Devar's case, and also there are connected other cases Vadivel Deva's case in the year 1957. That is also very old case. And in connection with this case, you can also go through this Gulam Sarbar case, which these two cases say this evidence is always weighed. No particular number of witnesses is required. Only the quality is required. The quantity is not at all importance. Quantity, keep aside the quantity. The quality is a substance. So on the basis of the on the basis of the quality, you can convict a person. It is weighed and it is not counted. Repeatedly the words are being used. It is weighed and it is not counted. So this is what is the dictum in this Vadivel Deva's case as well as in the Gulam Sarbar case. So following these cases, so many other cases have come. If you want a detailed research on it, you go to Allahabad High Court judgment judgment called Naresh versus State of UP, where an elaborate discussion will be there. How they will rely upon 4 more judgments from Tamil Nadu also. I think one is R. Mugam, one is Saravanan, one is Dr. Sunil Kumar, one is Pradap Singh, Pradap Mahendra Singh. These are the 4 judgments they will rely upon to conclude that how the witnesses are to be appreciated, and how this conclusion has to be arrived on the basis of their depositions in the court. Please go through the judgments, which will be very useful for you. And so 134, I think that probably you could understand this 134. If you want further judgment also, I can say that. Along with that, you please go through one another judgment by name called Tahsildar Singh. That is pertaining to chief and cross, but the witness, about the witness also, they will deal with that. This is also a very elaborate judgment, which is running about to 30 pages. And one another judgment I want to say is, one is Gangadhar Behura. You can just note down, please note down. Gangadhar Behura is one another judgment, which is also very important, pertaining to this appreciation of the witness, how the witnesses have to be appreciated. You can go through that judgment also. And I think probably that with this conclusion of this 134, I am concluding the chapter number 9 of the Indian Evidence Act. Then we will have to proceed to the examination of how these witnesses now we have dealt with. How the witnesses have to be examined before the court of law. You also know that there will be a chief examination, there will be a cross examination, there will be a re-examination. This is by procedure we will know that chief, cross and the re-examination. This is how the examination is going. We used to adhere to, or we experience what we experience in the court of law as a chief, cross and re-examination. And what are the procedure prescribed therefore for this purpose of this examinations. So here 135 simply says the order of production and examination of the witnesses. Excuse me for a second. That Murugesan case I said in Thoothukudi is Vilathikulam. That court is called Vilathikulam. I just got it recollected. That is Vilathikulam. You can just put it in the India Kanun, Vilathikulam Magistrate Court. Just a second, excuse me. Sorry, some sound emanating from my house, so therefore I just locked the door. Just have a mark on it that it is Vilathikulam police station and Vilathikulam Magistrate Court, that Murugesan case. Then here 135 says, so we will first have a glance of these sections, then we will have a comparative chart within which how the chief and cross examination could be carried out and what are the areas, bounds and bounds for the advocate to cross-examine a particular witness, and chief examine a particular witness, and chief is by the prosecution, cross will be by the defense. And in case of 154, in case of hostile witness, how it could be treated, what are the rights of the defense counsel, or what are the rights of the prosecution witness who called the witness, who become an hostile witness, and what is the evidentiary value of this hostile witness. That is most important, which we'll have to see. And so for that purpose, we will first have an understanding about what is stipulated in the examination of witness in the Evidence Act, and then we'll go deep into that, dwell into this deep into the sections. Okay. First, the order of production and examination of the witnesses. The order of production in which the examinations are produced and examined shall be regulated by the law for the timing in practice. In case if the law has not been regulated, then by the discretion of the court. Here one discretion has been given to the court to regulate the proceedings of production of examinations by discretion, which is not applicable. Now it is regulated by law. We can take it is now regulated by law. Here 136, judge to decide the admissibility of the evidence. We already dealt with in the chapter number 2 itself that what is the relevancy. Only if it is relevant, it could be admitted before the court of law. If it is not relevant, it cannot be admitted before the court of law, which already we discussed. So here, if it is relevant or not relevant, by means of this admissibility in the evidence, here say judge to decide the admissibility of the evidence. By means of this judge to decide the admissibility, he will decide whether it would be relevant or irrelevant. If it is relevant, it will be admitted. If it is not relevant, it will not be admitted. So here 136 gives a discretion to the judge. I'll just read the section. When either party proposes to give evidence on any fact, judge may ask the party proposing to give evidence in what manner if the alleged fact, if proved, would be relevant, and the judge shall admit the evidence if he thinks fit, if he thinks that the fact proved would be relevant and not otherwise. You see this, the word that is given here is not otherwise. So here there is an exclusion clause that's been given. The area in which even judge cannot by means of law take advantage, go beyond law and admit an irrelevant fact and bring it in the relevancy and put it in the 136 for the purpose of admission into, for the purpose of admitting that in the court. This power, that's a special power that's been given to the judge pertaining to decide the admissibility of the evidence. Then here judge here mandates the section here mandates the judge to put a question. See here the evidence either party proposes to give evidence. Judge may ask, here you see please, judge may ask the party proposing to give evidence. He shall ask, or he may ask, or he had to ask to the party who is proposing to give evidence in what manner if the alleged fact, if proved, would be relevant. He has to put a question to them what manner it is relevant. Suppose if the counsel is not able to explain in what manner it is relevant, judge shall say that I will not admit irrelevant. Judge shall admit only if he thinks that the fact if proved would be relevant. See the words here. Only if he thinks that the fact if it is proved, it would be relevant. Not otherwise. I'll link it with the section 5 and I'll discuss later. You just first I'll give a general explanation about it. Then we'll have to link all the 4-5 sections for the purpose of seeing what is your limitation part for the cross-examination. Here the 136, there is a power is given to the judge for the purpose of seeing whether it is admissible or not. Put a question to him if it is proved, in what manner if it is proved, what manner it is going to be relevant if it is proved. Then he has to give a satisfied answer. To the satisfaction of the judge, the counsel has to give an answer that it is relevant. And if the judge, only if he thinks that the fact if proved would be relevant, he can admit it. Otherwise he cannot admit it. Here this is what the 136 says. Then the 137, which will be the definitions for the examination in chief, cross-examination and re-examination. Examination by chief examinations are by the examination by the party who calls him shall be called as examination chief. The examination of the witness by the adverse party shall be called as cross-examination. The examination of the witness subsequent to the cross-examination by the party who calls him shall be called is cross-examination. These are the three varieties of examination that it's been elaborated here. Nothing but if he desires, then he can cross-examine. The adverse party show, if the examination of the witness by the adverse party shall be called as, it's only a simple definitions about the examination in chief, cross-examination and the re-examination. Then you come to section 138. 138, witness shall be first examined in chief. Then, if the party so desires, if the adverse party so desires, he can cross-examine. Then, if the party calls him so desires, re-examined. The examination, cross-examination must relate to, here you see the second part of it. Here it contains two parts. First one is, the witness shall be examined in chief. The adverse party, if so desires, cross-examine. Then the party called him so desires, re-examine. But here, the next part you see, the examination and the cross-examination must relate to the relevant fact. Put a full stop here. Don't go further into it. The examination and the cross-examination must relate to the relevant fact. But the cross-examination need not be confined to the fact. See the wording here. It must be confined. Chief and cross must be confined to the relevant fact alone. But in the next part, well, we'll take it as a third part. We'll say that we'll let it be termed as a third part. But the cross-examination need not be confined to the facts to which the witness testified on his chief, examination in chief. Third part what it said, but the cross-examination need not be confined to the facts which had been testified in the chief examination. But it can go beyond the chief examination. Some of the relevant fact would have been missed in the chief examination. During the cross-examination, defense counsel wants to establish that missed relevant fact. He can now go beyond the chief examination and try to elucidate the relevant fact which was missed in the chief examination. He can do that. But he cannot cross the limit of the second part. He can, third part, I will once again read it. But the cross-examination need not be confined to the facts to which the witness is testified on the chief. Need not be confined. But what the second part says, examination and cross-examination must relate to the relevant fact. So, the third part is subject to the second part. Leave alone the first part. First part is very clear. Party calling him, chief examination. Adverse party so desires, cross-examine. Party calling him so desires, re-examining. First part you just leave it out. Second part, the chief and cross should be confined, should be related to the relevant fact. Third part is, but the cross-examination may go beyond the facts which were testified in the chief, but it should be within the limit of relevant fact. You cannot go beyond this. This is what the boundary that has been given here. If you transgress the boundary, where you can transgress the boundary? We can go beyond the relevant fact. Here in the connected note I will say, you can go beyond the relevant fact subject to 146, what has been explained in 146 of the Evidence Act. What explained in 146 of the Evidence Act? A witness can be testified pertaining to his veracity. Witness can be testified pertaining to his position in the life. A witness can be testified to shake his credit by injuring his character. To shake his credit, injuring these were the three ingredients, that important parameters that's been given here in 146. Beyond this 138 limit, relevant fact. If you cross-examine, you can cross-examine as to veracity, position and character. These are the three important things you can transgress. Otherwise, your limit is only if you are not going to this. Veracity is now for the purpose of attacking the witness. You are now testing the veracity, his position in his life and also his character. So why we are testing this? Permission has been given under 146 for these three go beyond this relevancy. To attack his impeaching his character, to attack his veracity, to attack his credibility. He is not believable, he is not credible, his evidence has to be thrown out. So for this purpose, this power is given to the advocates who are cross-examining under 146. We will come to 145, 146, 155, all are connected. We will come to that later. But I am saying, your limit can be transgressed, can be crossed over, border can be crossed only to the limited extent of 146. Otherwise, your limit is only within the relevant fact. If not confined in the, suppose some of the relevant fact is missed in the chief examination, that relevant fact can be elicited in the cross examination. That should be relevant. But anyway, you cannot cross the relevant fact and go beyond the second part of it. That's what the examination and cross examination must relate to the relevant fact. If you go beyond it, what is the consequence of it? We'll see that later. Okay, now cross examination is the person who is called to produce a document. A person is called to produce a document, which already we discussed. I think that in 131 also it's almost like a similar one. A person is called to produce only the document. He cannot be compelled to be he cannot be cross-examined. Cross-examination person called to produce a document. A person summoned to produce a document does not become a witness. By mere fact that he produces it, it cannot be cross-examined unless otherwise he is called as a witness. So a person who is simply called to produce a document, submit a document for the purpose of adjudication of the issue. He produces a document, but he cannot be examined as a witness unless otherwise he is called as a witness. He should be called as a witness. And examination, cross-examination as to the character, which is also relevant to 136, 146. Witnesses to the character. Witnesses to the character will be cross-examined and re-examined. Witnesses to the character. Then we'll come to the certain parameters on which the questions could be asked. First is leading question. You know that leading question is suggesting the answer. I need not have to explain. You will be having more experience in the trial court, and so therefore much of the discussion is not required in this. Suggesting the answer. Any question which is suggesting the answer, which the person pulling it wishes or expects to receive, is called a leading question. The answer is expected and you are giving a suggestion to him in the question itself, that becomes a leading question. Leading question when shall not be asked, must not be asked. Leading question 142, I am saying about the 142. Leading question must not, if objected by the adverse party, be asked in any examination chief or in the re-examination except with the permission of the court. So with the permission of the court it could be permitted, or in the, if it is an admitted fact also it could be permitted. But leading question must not, if objected by the adverse party, be asked in the examination of the chief. Leading question should not be, in general, leading question should not be asked in the chief examination. That's what the 142 stipulates. Then we come to 143. When it can be asked? It can be asked in the cross examination. So what is your bound? Whether you have an unlimited boundary to cross examine a person, keeping the person in the box. Where did you go last year? When did you come last year? Well, last year, from where you came? Where? These are the things you are not supposed to ask unless otherwise relevant under section 138 bounds. 138 second part. Keep it again and again. I am saying, keep it in your mind. The 138 second part. We will have a comparative discussion also, just 10 or 15 minutes only, and so that understand what is the bounds, and if you transgress the bound, where you have to land in, and but the judges are not doing that. So taking a leniency, giving some leniency and leverage to the advocates, and they are not really using their powers what they possess. Once we transgress into the cross, that some limit is given, and what extent you can go beyond the limit is also provided in 145 and 146 of the Evidence Act. And if you transgress the limit, what would be the consequences also is being provided in the Evidence Act. So now it is 143. We are now in 143. Leading questions can be asked in the cross-examination. Always when you have leading questions can be asked in the cross-examination, bear it in your mind, you have a barricade under 138 of the Evidence Act. Here now comes the 144. Evidence as to the matter in writing. Here any witness may be asked while under the examination whether any contract, grant, disposition of the property as to which he is giving evidence was not contained in the document. Simply without showing the document, you can be simply examined that the terms, the witness may be asked while under the examination whether contract, grant, property, disposition of the property as to which he is giving evidence was not contained in the document. If he says that it was contained in the document without marking the document, you see the second part. So a person could be cross-examined as to the contents of the document or the contract and terms of the document. If you see the second part, only if the document is available in the court. Keeping the document away from the court simply cannot be asked. If you go through the full section, we'll come to know about that. Please go through that. And was not contained in the document. If he says that it was contained in the document, or if he is about to make any statement as to the contents of any document, which in the opinion of the court ought to be produced. Opinion of the court is that document ought to be produced. In that case, the adverse party may object to such evidence being given until such a document is produced, until the facts have been proved which entitle the party who called the witness to give the secondary evidence of it. Leave the secondary evidence of it until the document is produced. The party, other adverse party, can object to such evidence. I am without producing the document, I say that I have a contract with some X. The terms of the contract are this. So is it not hit under section 91 and 92, what we yesterday dealt with? So the terms of the contract has to be proved by the document itself. So therefore the 144 has to be read along with the section 91 and also along with section 92. Exclusion of the oral agreement. 92 is the exclusion of the oral agreement. Here it is similar to that. Here also you are not producing the document, and without producing the document you are tend to admit those terms of the document, in which case the opinion of the court, you cannot give any evidence unless otherwise the document is produced. And also the adverse party can also oppose it. You produce a document and give evidence of it. That's it. The 145, 144. This is an examination. Evidence as to the documents in writing. Evidence as to documents in writing. If you want, you can connect it with the section 91, section 92, section 62, section 61, 62, 63, 64 and 65. All these things are here. Which are integrated. 61 I said, document should be proved by means of the primary evidence and secondary evidence. What is primary evidence? Document itself is produced before the court of law, it's a primary evidence. What is secondary evidence? A copy or mechanical process or compared copy written. All these processes are 63 63 evidence, that's secondary evidence. 64 evidence says a document shall be proved by the primary evidence alone unless exempted under the 65, under section 60 of the Evidence Act. This is what 61, 62, 63, 64. Along with that, if you compare it with the 91 and 92, 92 and 91 says the contract of the terms of the contract or a grant or disposition of the property, it shall be proved by the document itself. And any oral agreement cannot be permitted, they are excluded from being given as evidence. It's a 92. So therefore, all these four sections, 61, 62, 63, 64, 65, 91, 92 and 144 should be read along together. Jointly it should be read so as to understand the comprehensive meaning of this. So we will come to the most important part of examination. That's examination, cross-examination as to the previous statement in writing. This is, I think it is visible for you all. Cross-examination as to the previous statement in writing. Please go through this section 2 or 3 times and so as to give a clear picture about it. It contains 2 parts. First part is a witness may be cross-examined as to the previous statement in writing made by him, which is reduced into writing as to the relevant matters in question without such a writing being shown to him or proved. Without even showing to that, it could be proved. But if you are intended to contradict the him, if it is intended to contradict, second part is if he is intended to contradict him by writing, then his attention must be drawn, attention must be called to those parts before it is going to be proved, before the writing can be proved. His attention be called to those parts of it which are to be used for the purpose of contradicting. This contains 2 parts. First part is without showing the document, simply cross-examining him. Second part would be that showing the part of it and to say that you are now contradicting with the deposition here. The earlier part you said is totally different, and the part you are now saying, that the fact you are now saying here is different, and totally you are in omission or in contradiction. So therefore, whether you admit it or not, give me the explanations for it. This is how the opportunity for explanation is given under section 145 of the Evidence Act. Then the 145 Evidence Act has to be read along with the section 162 of the CRPC. Please go through the 162 of the CRPC also. What CRPC 161 and 162 says, it has to be conjointly read along with the 145 of the Evidence Act. So once you are, I'll give a small narration. under 145, you are cross-examining a particular person. He tends to give some false evidence which is not given in the previous statement. That is 161 and 162 section. For better understanding, we will take a criminal cases because it's practically it's not applicable in the civil cases. For better understanding of the 145, you are must and mandate you have to go to criminal cases alone. Here in the 145, you are permitted to cross-examine without showing the document whether this happened, that happened, leading question, all these things you can ask. And if you want to contradict him, that attention should be drawn to those part, the contradiction. What is the contradiction? That attention has to be drawn, and you have to seek an explanation. It's in consonance with the principles of natural justice. Why did you say like that? You said A there, you said C here. So why don't you say C there? C is there in the previous statement writing, but you are saying here, A is there in the previous statement writing, but here you say C. So why there is a contradiction? Give an explanation. If the explanation is acceptable to the court, then the contradiction is overruled. If the explanation is not acceptable to the court, then the contradiction survives and the credit of the witness will be impeached. That is the main purpose of this 145. We will go to 145, 162 also, just will have a glance. Then 145, then next, while cross-examining him, what are the questions which are legally permissible? See, what are the lawful questions in the cross-examination? Legally, questions which are permissible. I already have explained, pertaining to veracity, pertaining to the position, pertaining to his credit, shake the credit by injuring the character. Here I highlight it, please see this. To shake credit by injuring the character. So these are the three things which you can go beyond 138. Just bear it in your mind that 138 said chief and cross-examination must relate to the relevant facts, and 146 you can go beyond to that with respect to the veracity, with respect to the position, with respect to the character. These are the three areas where you can go beyond. Okay. So now we are coming to the 147. Already I said 147 and 132 are linked. We'll just keep it aside, and first we will complete this area, then we will come to when the witness is compelled to answer. The compulsion is also relating to the matter in proceedings. When the question relating to the matter in proceedings or relates to the matter relevant to the proceedings or suit. Relevant to the proceedings means relevant to the question involved, A killed B or not. Suppose if the question is relating to A killed B or not. Suppose it's related to the relevant to the proceedings, then he is compelled. When he is compelled, I am the witness, I am compelled to answer. In that compulsion I am answering, but I say there is forcibly I have to say at the time of incident I also accompanied along with the accused. This is a word which is coming out from the mouth of the witness. If that is coming out, it needs to be presumed that I am also an accomplice I am also part of that crime. So that will tend to incriminate me or tend to penalize me. If tend to penalize me, whether the proceedings can be initiated against me, whether it could be arrested or not, all the questions, that is what the safeguard that is given in 132. 132 says no excuse for the witness. There is no excuse for the witness if the answer which he gives tend to criminate him or tend to penalize him or forfeiture of the property. That will leave the second part and third part for the better understanding. We will take only the first part. If the answer is first mandatorily under section 147, the question must relate to the matter relevant to the suit or proceedings. Relevant to the issue. We will take relevant to the issue. If it is relevant to the issue, as per 138 also, we will have to chief and cross only pertaining to the relevant fact. So, if it is relevant to the issue, and if the relevant answer that I am giving is incriminating the witness against, if I am going to be the witness, the answer is going to incriminate me, I am protected under section 32 of the Evidence Act. No excuse, but provided if it tend to incriminate me, no proceedings can be initiated against me or no arrest could be effected against me. I cannot be arrested, no proceedings cannot be initiated against me. That's what the 147 and 132 has to be link together. What here it says is, see the stipulation of the section here, if any such question relates to matter relevant to the suit or proceeding, the provisions of section 132 applies there too. See here directly 147 says, so if it related to the question issue, related to the question, you go to 132. Here 147 directly we are shifting our route to the 132. So here let it stand as such. You take an example of this Banu's case and the Dina case, which is pertaining to the death of fastest son of MGR, former Chief Minister of Tamil Nadu. This murder of the former Chief Minister's fastest son. So in this case, the Honorable High Court has dealt with this 147 and 132 elaborately when a witness is compelled to answer. If he is a witness before the court of law, whether Article 20, subclass 3, no one can be compelled to be a witness against himself, is applicable in this case or not. If he is a witness, whether he is unapplicable or not, that question is also dealt with. And the second question is that in the case of the approver, whether the transaction, when the conspiracy has been cut, whether it is part of the course of the same transaction or not. That is also the question that's been dealt with. Different complicated questions that's been dealt with in that case. Just go through that, you can understand. For the time being, you can minimize this your understanding with the 147 when a witness is compelled to answer. I cannot say that I am not compelled to answer, I cannot go. Suppose if the matter relates to, because you are duty bound to say truth under section 8 of the Votes Act. Always keep it in your mind while dealing with the Evidence Act. Under section 8 of the Votes Act, you are duty bound to say truth before the court of law. As because we are compelled, you cannot say simply, no, I am not compelled, I cannot give you the answer. I will evade the answer, I will give a false answer, I will lie before the court. That amounts to a lie. We will be transgressing the section 8 of the Votes Act. So always keep it in your mind that these sections are connected with the section 8 of the Votes Act. Then comes the 148. Here, I think time is going up. Okay, 148 will where the court to decide when a witness is compelled to answer. Here you see, if such question relate to the matter not relevant. See now here comes the 38. You compare it with the 138. I said chief and cross should be confined to the relevant matter. If the question is here, what it says. If the question relates to the matter not relevant to the suit or proceedings, totally an unconnected question is asked. Totally an irrelevant, unconnected question is asked. Except in so far as it affects the credit of the witness by injuring the character. That is 146 I said 146 you are given a leverage to go beyond the second part of 138. Suppose if you are completely going beyond the 138, that is relevant fact, and you are landing up in now 148. 148 is the question is asked which is not relevant. So here comes proper question, improper question, and these are the two questions that's been dealt with here in this case. So suppose if the such question is proper, see here court shall have a regard to the following consideration. I will just go through the section fully. In any such a question relates to the matter not relevant to the suit or proceedings except in so far as it affects the credit of the witness by injuring the character. This is what the exact word in 146. The court shall decide whether or not the witness shall be compelled. Court shall decide whether or not the witness shall be compelled. And if the court thinks, warn the witness. See the word. If the court thinks, warn the witness, you are not obliged to answer. It is not required for the witness to answer any irrelevant question. That's what it means. In that instances of asking any irrelevant question, the court can warn the witness, you are not obliged to ask. In the exercising the discretion, court shall have the following consideration. Following things may be considered. What it says, such question is considered to be a proper question if they are of such a nature, the truth of imputation, what is the imputation which we are putting on the witness, is seriously going to affect the opinion of the court as to the credibility of the witness. See that the imputation you are going to create, that is a proper question. Because the imputation is permissible under section 146. Here 148, we are in the 148. 146 imputation, he is dealt with here also in 148. Suppose you are putting an irrelevant question, that irrelevant question is connected to the imputation. That imputation is going to seriously affect the opinion of the court as to the credibility. If the opinion of the court as to the credibility is impacted, it is proper question. Suppose if the opinion of the court as to the credibility is not affected, you are imputing a person, imputing the witness, that imputation is going to be proved, and that imputation is not going to affect the opinion of the court as to the credibility, it is an improper question. Then the question is also improper if there is a great disproportion and distance between the importance of the imputation and the character. Imputation, that's importance of the imputation and the importance of the evidence. Suppose completely an unimportant evidence it is. Completely it is not an unimportant. Completely it is an unimportant. It's not important evidence. Then what is the purpose of imputing that evidence? No purpose will be solved. So therefore, then in that case also, that is an improper question. Then the fourth one is, court if it sees fit, draw an adverse inference. If this answer is going to be given, it will adversely affect his, it will be unfavorable to him, or it will adversely affect him, unfavorable to him. These are the four things which the court has to take into consideration. So this is 148. 140, as per the 148, the court shall warn the witness that you are not obliged to answer. Here it's important. We will go to comparative chart. Just we'll complete this. Then 149. Suppose your questions are not well founded. You are asking some questions as to the imputation, but that is not well founded. But it is a malicious one, or without having any basis, or without having any evidence. Here, the questions not to be asked without reasonable grounds. There is a checkpoint that is being given here for the cross-examination and the advocate's power to ask cross-examination, and the power to cross-examine. No such questions as is referred to under section 148 ought to be asked unless the person asking it has a reasonable ground for thinking that imputation which it conveys is well founded. Imputation which it conveys is well founded. So unless it is well founded in imputation, such imputation questions shall not be asked. Should not know such questions as referred to in section 148 ought to be asked unless it is well founded. 148 imputation questions should be asked. In other words, we can say 148 imputations under 148 imputations questions could be asked only if it is well founded and with the base and with proper strength. Otherwise, if it is not well founded, it becomes an unreasonable question. In case of unreasonable question, where you land up. Then it comes to 150. When you come to 150, the court, in case of the question being asked without any reasonable grounds, if the court is of the opinion that such a question is asked without reasonable grounds, it may, if it was asked by any barrister, pleader, vakil, attorney, report the circumstances to the High Court or any other authority to which such a barrister, pleader, vakil or attorney is a subject in the exercise of the profession. Please see this, 150. I hope I believe that this provision has never been used by anybody else in any courts. Here, there is a checkpoint that is given. That's what I said, that in 138, 136, 138, 148, 149, 150 has to be compared together. If all these things are compared together, you will come to know about the limits of the cross-examination within which we can travel. If it is going to be unreasonable, you are in second part of the 138, you have to confine your chief and cross with the relevant fact. In the relevant fact alone. If you have to cross it, you can cross it to the level of 146 Evidence Act. Veracity, position and character. That is attacking the imputation. If you come to the imputation that is prescribed in the 148, what are the imputation? Proper question, improper question. Imputation which has to affect the opinion of the court. That alone is a good. Otherwise it is a ill-founded. Ill-founded means not well-founded. If it is well-founded, if it is not well-founded, it will fall under section 149, unreasonable question. Questions which are without any reasonable grounds. If it is 149, the court can give a submit a report to the Bar Council or to the High Court, under which we are doing our profession. This is a 150. This is therefore this is the framework of. Then we will come to 145, 146 and 155. That is the chief and cross examination. First we will complete this part. So along with this 150, you also please see the indecent and scandalous question which has to be avoided. Court shall forbid. Court may forbid any questions and inquiries which regard to the indecent and scandalous, and also the question intended to 152. The question intended to insult and annoy the witness. Insulting the witness, annoying the witness is also to be forbidden. Court shall forbid. Here may forbid. Scandalous and indecent is may forbid. See the word here, may forbid. But here court shall forbid any insult and annoyance to a question which appears to be intended to insult or annoy or such, or which through proper in itself appears to the court needlessly offensive in the form. Right? Court shall forbid the questions which are intended to insult and annoy. So along with 150, you have to take into consideration the 151 and 152 also. Now we will go to a chart and we will come back to the another important chapter, that is 145, 146, 155 and connected to 162 also. That is the second thing which I will take. And so before that, then one another thing is 154, hostile witness. I will reserve. I will come to first if I will finish up this and then I will come to this. I will share another document with you. Then I will close this. This document is visible, sir? Stop sharing. I'll take another chart, it will be in red.
Yes, sir. It's on.
Yes, madam. Now,
Yeah.
see, why I have said your cross-examination power is limited. See, you compare it with, this side I have given section 5, this side I have given 136, below 136 I have given 138, and below 138 I have given 147 compared to 130. That's not required, just forget it, 147. 148, below that 148 I have given. And below that I have also given 149 and 150. And along with the 150, I said that scandalous and indecent, insult, annoy questions should be avoided. Along with the 151, 152, just go through that. But for the purpose of the relevancy, I am taking out this. I am just showing this, please see the chart. See, under section 5 of the Evidence Act, I have given 5 of the Evidence Act. Under section left side, under section 5 of the Evidence Act, what Evidence Act 5 stipulates is that evidence may be given in any suit or proceedings, the existence and non-existence of every fact and issue and other fact, and of no others. The evidence may be given only as to the fact in issue and the relevant fact, and of no others. Here there is a bar that's been put for us. Evidence cannot be led with respect to the irrelevant fact. So this section 5 is now compared along with section 136. Here, I have given here, please see this. The either party proposes to give an evidence of any fact. Judge may ask, judge is putting a question to us, what manner the alleged fact if proved, here it is written, what manner the alleged proof, if it is proved, would be relevant. Judge shall admit that evidence if he thinks that if it is proved it would be relevant and of not otherwise. Here you see the and of not otherwise. Here and of no others have some connection. Section 5 and of no others go. In section 136 not otherwise go. There is a connectivity. Judge shall admit only the relevant fact alone, not the irrelevant fact. See the connection between these 5 and 136. Here, the question, you shall question. Here I have given the mandate of 136. Put a question, what manner, if it is admitted, it would be relevant. It shall admit only if it first put a question, what manner, if it is admitted, it would be relevant. And shall admit only if it is relevant. Number 2. under section 136. I am saying under section 136. Number 3, not otherwise. Here says not otherwise. So if it is not going to be relevant, he will not admit that answer at all. Here, warning is given under section 148. We will go to 148 later. Okay. Then here 136 is compared with the 138. 138, witness shall be first examined in chief, and so desired. This is a part number 1. The part number 2, this is so important part. The examination and the cross-examination, excuse me. The examination and the cross-examination must relate to the relevant fact. And what is the third part says? It need not be confined to the facts to which the witness have been testified in the chief examination. You can transgress the facts from the facts which have been testified in the chief examination, but it must relate to the relevant fact. Must relate to the relevant fact. That's what the part number 3 is. Part number 3 is subject to the part number 2. You can transgress from the fact which had been examined in the chief, but as per the part number 2, your cross-examination must relate only to the relevant fact alone. This is part 138. So if you are violating it, you can. What is the exemption to this 138 second part? Exemption to the second part is here. You come to 146 here. 146 here. Test the veracity, not list. Test the veracity. Wrongly typed. Test his veracity. Discover who is he in his position in life, and shake his credit by injuring the character. So these are the 3 important criteria in which you can violate. For which you can violate you can deviate from the 138, which pertain to the testing the veracity, position, and character. You can testing the character. Suppose this 146. Beyond, you are asking the questions pertaining to the imputation. Under section 146, you are within the 146 now, and you are asking the question pertaining to the imputation. Now you are coming under 148. If your question is not related to the matter relevant, if it is such a question relates to the matter not relevant to the suit or proceedings. Now you see this not relevant to the suit or proceedings, but yet it pertains to the imputation. It is not relevant to the suit or proceedings, but it yet pertains to the imputation. Then in such a case of imputations, then the imputation is going to affect the opinion of the court, it is proper. If it is not going to affect the opinion of the court, it is improper. That's the 2 things that you have to bear. Other 2 things are there. These are the 2 things which you have to bear in mind. Here, if it is not relevant to the suit or proceedings, except in so far it affects the credit of the witness by injuring the character, the court shall decide whether or not witness shall be compelled to answer. Here, the court will have a discretion to decide whether you are compelled to answer or not, whether the witness is compelled to answer or not. In those cases, it can warn the witness that he is not obliged to answer. See here, I have written. This is what the exact reproduction of the section here. Reproduction of the section. What is the words that's in the section? You are now warning the witness you are not obliged to answer. Even then, if the imputation question is asked without reasonable grounds, not well-founded grounds, then the court can submit a report under section 150 to the High Court or to the authority under which the Vakil advocate attorney is a subject in exercise of his exercise of his profession. So a report could be forwarded if it is going to be a ill-founded imputation question and not relevant to the matter in question, not relevant to the matter. So therefore I am saying, when compared with, so again I'm going back to this area, this please see this 531 as per section 136, as per section, here I have written the gist of it, the extract of it I have written here, which I have highlighted, as per section 5, as per section 136, as per section 138, as per section 148 and 165 it's a judge's power to put a question to any witness any point of time as to any relevant question, it may be irrelevant question, or may ask to produce a document at any point. Judge's power under section 165. We will come to that later. But anyway, we compare it with section 5, 136, 138 and 148. You see that And the section 5 says, and of no others. Don't don't let in evidence, give evidence pertaining to the irrelevant matters. Section 136 says, shall admit only relevant, not otherwise. See, 136 says shall admit only relevant, not otherwise. Then comes 138. 138's chief and cross relate to the relevant questions alone, relate to the relevant facts alone. That is 138 mandates. Now, under 148, there is a warning that has to be given by the judge that you are not obliged to answer. This is what is the framework. Then, to find out the truth of the issue, judge may to discover and obtain the proof of the relevant fact. 165. Here I have written 165. To obtain the truth and obtain the proof of relevant fact, judge may ask any question, relevant, irrelevant, to any party or any witness, any time, any form, and production of any documents also. This is a power under section 165 of the. So leave alone the power under section 165. Now when you compare it to the 536, 136, 138 and 145, 148, and of no others is one of the important thing. Not otherwise is another important thing. Chief and cross must relate to the relevant fact is the another thing. And the judge shall warn the accused that you are not obliged to answer is another thing. And also under 136, judge can also put a question in what manner if it is going to be admitted, it would be relevant. Suppose the judge thinks that it is not relevant, he shall not admit it. He shall not admit it, and not otherwise. That is, here there is a not otherwise is given. So these are the four sections 5, 136, 138 and 148 which puts a boundary to you pertaining to the cross-examination. Beyond the boundary, if an advocate travels, then the consequences would be that it would be an unreasonable question under section 149 and the report could be submitted under section 150 to the Bar Council or the High Court as per section 150. This is what its mandates. Now, this I think that this cross-examination area and bounds, I think that I have done it. Then we will come to 145 of the Evidence Act. 145 of the Evidence Act is cross-examination as to the previous statement writing. Then I'll close down this shot and again I'll skip over to my own this. I'll go to the Evidence Act now. Here now we'll come to the next chapter as to the cross-examinations to the previous statement, how to elucidate the contradictions. That is the important thing in this 145. I already said there are two parts in this 145. I'm not going to read the section again. I'll just give an extract about it. I'm just giving an extract about it. A witness shall be cross-examined without showing the document to him. But once you want to contradict him, his attention must be drawn to those documents or part of the documents which are used for the purpose of contradicting. If you contradict, this 145 has to be read along with section 162 of the CRPC. 162 of CRPC, I'll just read it. 161, you know that any person acquainted with the facts and circumstances of the case, he has to disclose the facts, truth to the police officer under section 161 of the CRPC. Then the police officer who is taking the facts and circumstances from the witness or the prospective witness, he has to reduce that into writing. This writing will become a previous statement in writing as per section 145 of the Evidence Act. This is a previous statement in writing. If you compare this 145 with the section 162 of the CRPC, 162 I'll give a glance of it. See, the 161 statement cannot be used for any purpose, And if it is going to be proved, the fact which is stated in 161 is going to be proved in the court also, then it could be used only for the purpose, cannot be used for any purpose except the contradiction under section 145 of the Evidence Act. That's what the reading here. It cannot be used for any purpose except to contradict the witness under section in the manner provided under section 145 of the Evidence Act. This is what is so 162 and this 145 both are relevant. So once you contradict that witness under section 145, then the veracity of the witness will get impeached. What he stated there one point of time before the police officer is a different thing, and what is he stating before the court is a different thing. Therefore, the credibility of the witnesses goes out. Once the credibility of the witnesses goes out, where he will land? 145. The consequence of the 145, already 146 I have discussed. 145 you can also see 145 is for the purpose of cross-examination and for the purpose of contradicting the witness. 146 is for the purpose of impeaching the witness. The 145 and 146 both will land up in 155 of the Evidence Act. What 155 of the Evidence Act says? Impeaching the credit of the witness. Here, 155, it says the credit of the witness can be impeached by the following ways: by the adverse party, or with the consent of the court by the party who calls him also, by evidence of a person who testify that from their knowledge, from his knowledge, the witness believes him to be unworthy of credit. That is, by means of a person, by testifying a person, that person will testify and say, depose before the court, that the witness is unworthy of credit. Who's that? The earlier witness. I am leading another witness here in the defense. This defense witness will say, no, that witness is unworthy of credit. That's what is the first paragraph. Second one is, he accepted some bribe for the purpose of giving this evidence. So here, by proof of the witness has been bribed or has accepted an offer of the bribe and has received any other corrupt inducement for the purpose of giving this evidence. By proof of the former statement inconsistent with the part of his evidence which is liable to be contradicted. By proof of the former statement. I am giving a former statement which is something like FIR, and the FIR is inconsistent to the any part of the evidence now testified before the court which is liable to be contradicted. Suppose in the FIR he says A and B attacked. Here before the court he says C and D attacked. There A and B is totally different in the former statement, that is FIR. Here C and D is totally different, which is before the court of law. So therefore, by proof of the earlier former statement, that is the FIR, you are now contradicting the evidence before the court. See that what you have stated is not stated in the FIR. Therefore, your credit is impeached. This is what the impeaching the credit. See, apart from these three parameters which are stated here, also that 146, the effect of 145 and the effect of 146 also will land in 155, and the credit of the witness will be impeached and his credibility will be reduced and he will be liable to be rejected. This is how the scheme has to be seen. This is 145, 146 and the effect would be 155, impeaching the credit of the witness. This is how it has to be explained. So now we will go to, I hope that you will understand this. For this purpose, 145, we can, I will give a small illustrations which is illustrated in Magesh versus State. Magesh versus State, you can go through that. And also Sudhagar versus State is also second case. Again, both are from Madras High Court. Very detailed explanation about the contradictions. And one another case, Tahsildar Singh's, if you want to go further research in this area, you can go to Tahsildar Singh's case. That is Supreme Court judgment. In the Magesh case, a boy will come, the accused will come inside, he will trespass into the house, attack mother, he will kill the daughter after raping her, after committing a rape. Mother will say before the court that at the point of time, I saw the accused. Before the court she will say that at the point of time I have seen the accused and he only entered and he ransacked everything and he killed my daughter also. But in the chief examination, in the 161 statement, a contrary view will be written there. At the time of entering this accused entering into my house, I was sleeping. This is how the 161 statement will say. But the appellant counsel before the court, the accused counsel before the appellate court, he will say there is a contradiction between the 161 and the deposition that's been given by the PW1 before the court. That this is the mother before the court. This is the contradiction. Then the court will overrule the contradiction, say whether this contradiction has been established as per the law, as per the 145. As per the law means as per the 145. What is 145? That's what has been explained there in Magesh case. That the first part, simply you can cross-examine him without showing the previous document, previous statement in writing, that is 161 statement. Second, you should have shown it and you should have asked for the explanation. Why did you say that at the time of entering I was sleeping before the police officer? This is what your statement in the police officer. Otherwise, what did you say before the police officer? This is how it has to be shown. But before contradicting him, before contradicting the mother, that part of the statement should have been shown to the mother and asked for the explanation. Why did you say like this? Now you are saying a different thing. That explanation should have been offered to the judge, pertained to the contradiction. If it is accepted by the judge, then the acceptance will be the effect of the acceptance will be that it will nullify the contradiction. Suppose if it is not accepted, the credit of the witness or the credibility of the witness will be impeached before the court. This is how the first one example. Second one is the Sudhagar's case. In the Sudhagar's case, in the first accident report, the deceased sons will take him to the deceased will be attacked by the accused, about 3 or 4 persons. Both are relative. This group, accused group and the deceased group, both are relative. The deceased son will take him to the doctor. 2 sons will take him to the doctor. Before the doctor, they will say that the incident happened before the accused house. Before the court, they will say the incident happened before the deceased house. Before the deceased house, before the court. But in the accident register, the incident happened before the accused house. That's both are separated by about 3-4 kilometers. Now there is a contradiction that exists. This contradiction was about to be elucidated before the appellate court. That's before the High Court of Madras. Then the division bench said whether this contradiction has been elucidated as per the law. This is the first question. That's as that of the Magesh case. Magesh case also, you have to show the contradiction and you have to offer him an opportunity, explain it or rebut it or disprove it. Either of the 3 opportunities should be given, rebut it or explain it. If the explanation is going to be accepted, the contradiction will vanish. If the explanation is not going to be accepted, the contradiction will survive. So the Sudhagar case and Magesh case will be the simple case for the purpose of understanding what is contradiction, how it has to be elucidated as per the law. Otherwise, the court can simply reject it. No, this contradiction cannot be taken. This contradiction has not been established as per the law. So these 2 cases. Apart from these 2 cases, in the Sudhagar case, the Honorable High Court Judge will also rely upon one case by name Bhagwan Singh's case in 1950s and another case Ranjinder Prasad's case. This case is also 1960 somewhere. And third one is some Nagar Singh's case. For the purpose of contradiction, elucidating the contradiction, you can see all these 5 cases. I'll say once again, Magesh. Then next one is Sudhagar. Next one is Bhagwan Singh. Next one is Ranjinder Singh. Next one is Nagar Singh. Nagarshingh. Nagar Singh. These are the 5 cases we can treat as far as the elucidating the contradictions as per section 145 of the Indian Evidence Act. This. I will now close this and I will come to this another chart. And this are now the chapter of 145, 146 and 155 as I have completed that. What is remaining is 154. I think time is going beyond 1 and just give me 10 minutes or 15 minutes. I will just try to finish it off and I'll just show you another chart which now only thing which is left is that I think that 154 hostile witness, 154 and 157. We have two more topics which we have to cover. 154 which is hostile witness and 157 which is the later testimony is the same fact can be corroborated by the former statement. Well, no, before that we will go to 155, then we will go to 154, please. 154 is not here. Once again I'll take the Evidence Act. So most important section, it is 155, 157. See, before that I will give a general introduction about the please understand the difference between the former statement and the previous statement. What are all the former statement which has not been defined anywhere in the Evidence Act or in the CRPC? What is former statement? Former statement is said or which is defined in the 157 Evidence Act. Previous statement is stated in the 145 of the Evidence Act. 145 says previous statement, cross-examination as to previous statement in writing. Please I will take you to the 145. Here you please see this wording here. Cross-examination as to previous statement in writing. See here, cross-examination as to previous statement in writing. So this is a previous statement writing or reduced into writing by somebody else. If it is a 161 statement, it is reduced into writing, so it becomes a previous statement. But what is former statement? Former statement is defined in 157. Here 157 says only two kinds of former statement. Here the statement which is given at or about the time when the incident has happened. This is, see this, in order to corroborate the testimony of the witness before the court. In order to corroborate means in order to strengthen, in order to give a strength to the testimony in the court, the former statement made by such witness, same witness, the former statement made by same witness relating to the same fact at or about the time when the fact took place or before any authority legally competent to investigate the fact may be proved. See, please understand. See, two things are defined here. One is the statement which has been made at or about the time when the fact took place, when the crime took place, at or about the time when the crime took place, or before any authority legally competent to investigate. Suppose immediately after the occurrence, I go and register an FIR. This is an statement which is given to an authority competent to investigate. So I am giving a statement, injured witness in the hospital giving a statement to the sub-inspector who came to register the case. So this is the statement given to the authority legally competent to investigate. This is formal statement. Another statement is the statement which is at or about the time when the incident has happened. So here I will give you example. In the Rameshwar case, child immediately after the mother comes, the child says that I was raped by so and so accused. This is the statement which is at or about statement, which is falling under section 57. This statement, if it is going to be deposed by the child as well as by the mother before the court of law, this substantive testimony of the child will be corroborated by this statement, the statement which is given at or about the time when the incident has happened. So this is what the statement I have given to my mother at the time the mother came to my house, and mother also will depose. This is what my child has stated to me. If these two statements are corroborative piece of evidence which will corroborate the real testimony which is given before the court as to the occurrence, as to the fact in issue. This is one example I can give, Rameshwar case. Second one is, if you take an High Court judgment by name Priya, wherein the deceased name will be Mala, where neighboring, the accused is of the neighboring house, accused will reside in the neighboring house. She will come because of some animosity. She will come and attack this lady mother, Priya, this Mala, the deceased Mala, in the early morning by about 6:30 or 7 o'clock. At the time I was about to get up from the bed. This will be witnessed by only daughter. The boy will be outside the house. The deceased will have one boy and one, both are child witness, one boy and one girl, and the girl will come and say, my mother has been attacked by auntie, neighboring auntie, let's say auntie. The boy will rush in and he will say that he will see his mother in pool of blood, and immediately will call his uncle and father who already has left for a job. So this statement which is given by this daughter, that's the sister, to the brother is the at or about statement. The statement which is given at or about the time when the incident has happened. This is the formal statement. Likewise, Rameshwar case, the statement which is given by the victim to the mother is also a formal statement. A statement which is given to the police authority for the purpose of registering FIR is the formal statement. A statement which is given under section 164 of the CRPC to the magistrate, 164 statement, I am not saying the 164 confession, 164 statement by the witness to the magistrate is the formal statement. Likewise, a statement which is given to the RDO for any death which is inquired by him for death of the female immediately within the 7 years of marriage or suspicious death, any RDO inquiry, if any any statement is given to the RDO or executive magistrate or a district collector, district magistrate, this will fall under section 157. This is a formal statement in writing. For this purpose, you can go to one Arulvail case. Arulvail case, Tudiyalur police station, that is also Madras High Court. You please go through that for the purpose of understanding what is a formal statement that is given to the now judicial magistrates are now empowered to investigate the custodial death and custodial rape once which has happened in the custody of the police under section 176 1A. So that if evidence is going to be collected, if he conducts an inquiry and records evidence, that is also will fall under section 157 of the Evidence Act. It's a formal statement in writing. All excepting this, all other statement are previous statement which will fall under section 145 of the Evidence Act, and it will be a formal statement which will be used for the purpose of cross examination. But this formal statement could be used for the purpose of corroborating the later testimony deposition before the court of law, and therefore it could be under section 157. This is said that any formal statement could be used for the purpose of corroborating the later testimony as to the same fact in the court of law. This is how the one formal statement and previous statement has to be distinguished. Then we will come to section 154 of Evidence Act, which is the hostile witness. Hostile witness is the witness which is hiding the truth or not willing to disclose what has really happened before the court of law. In that incidence, if you take the 154, in that incidence, the party who is calling him, he is empowered to put all questions put by the adverse party. That is almost like a cross examination for the purpose of elucidating the real fact, for the purpose of showing it before the court. So this for the purpose of elucidating what really has given in the previous statement in writing, that is in the 161 statement or 162 statement, and deposing before the court in contrary to that, we want to elicit. The prosecution will cross-examine it. It doesn't mean that prosecution is permitted to cross-examine. Prosecution is entitled to ask any question that could be put by the adverse party. That's it. It cannot be termed as a cross-examination. It is something like, you have now deviated from the version. I want to put you some question for the purpose of elucidating it. In those incidents, the court can take any part reliable, any part of the hostile, because he is hostile to the prosecution. It need not be that the entire prosecution has to be rejected. He can be relied upon still. He can be relied upon with respect to any part of that which the court inspires, which court is having a confidence, or which the part which inspires the confidence of the court. This is what the 154. If you want to if you want to take some judgments pertaining to the not outright rejection of the hostile witness, you can see Satpal versus NCT in 1965, some DVSC, the Vigilance and Anti-Corruption judgment it is. You can see Satpal Singh. It is Satpal, not Satpal Singh. It is Satpal versus Delhi administration. You can take it from the Indian Qanun. Satpal. Next one is, then I'll give one Madras High Court judgment, that is Murugan In that Murugan case, two important judgments will be extracted. One is Gura Singh, G-U-R-A-S-I-N-G-H. Gura Singh, 2001, 3 SEC 190, page number. Another one is Narayanan Nattu Nayak. That is 1971, 1 SCR 133. These are the two important judgments that's been extracted. I'll show you that extract of the page for your simple understanding. Just bear with me for 5 minutes. I'll just finish it off. Is that document is visible? Document taking is a big problem for me. Share screen. Yeah, here. I'll just go to the last page. Child witness, accomplice witness. For cross-examination purpose, you can also see Kannan versus State. Date of judgment is 12/4/2016, wherein the Kartar Singh case will be dealt with. Kannan versus State. This is 12/4/2016 for cross-examination. Now we are in 154. See, in this Murugan case, the Gura Singh's case will be extracted. Here, the hostile witness is described as one who is not desirous of telling the truth at the instances of one party calling him, and unfavorable witness is a one called by the party to prove a particular fact in issue or relevant fact in issue, and fails to prove such facts and proves an opposite fact. See, unfavorable witness is a witness who is will not be proving the fact for which he has been called to prove, but he will prove some other fact. That is unfavorable. But the hostile witness is one, he is not desirous of telling truth. So here in India, right of cross-examination, in right to cross-examine a witness, I'll just go through the paragraph from which you can understand. You can also search Gura Singh and Kannan case. It's a Kannan, it's a Murugan case, Murugan appellate. Please see the Murugan. And criminal appeal number is 708/2011, and in which this Gura Singh's case is extracted. What is hostile witness, what is unfavorable witness. And here in India, right to cross-examine a witness by a party calling him is governed by 154 of the Indian Evidence Act, which permits him to put any question to him which might be put to him as provided under section 142 of the Evidence Act. The purpose of section 154 of the Evidence Act is to provide an opportunity to the party who has called a witness to elicit necessary evidences in order to prove that fact in issue and relevant fact. Even if the witness so treated as hostile and cross-examined with the permission of the court, the evidence of the said witness is not washed off from the record altogether. Please see, not washed off from the records altogether. It is for the court to analyze the entire witness of the said witness. If the court finds reliance on any part of the evidence of the hostile witness in respect of any fact, it is not illegal to act upon the same. That is what is decided here in Narayanan Nattu Nayak, Maharashtra, 1971, 1 SCR 133. This is extracted in Gura Singh's case also. The Gura Singh is extracted in here Murugan's case. So this is how the 154 has to be considered. As because he is a hostile witness, it's not that you have to be completely, it has to be eschewed and it should be thrown out of the consideration. It could be considered if the court is having court finds reliance on any part of the evidence of the hostile witness in respect of any of the fact, it is not it is not illegal to act upon the same. That is the relied upon fact. So hostile witness also, in the hostile witness evidence, any part could be relied upon where court finds that this part is reliable. This is what has been elucidated here in this judgment. It's been propounded in this judgment. Okay. Apart from that, what is left out is 165. 165 is nothing but extraordinary power of the judge who deals with the case for the purpose of, already I read out in the chart, for the purpose of finding out and discovery of the truth in the fact of issue. He can put any question, relevant question, irrelevant question, ask for any document at any point of time, and the adverse party will not have any right, entitledness to object for it. This is a power under section 165 of the Evidence Act. Other two are just like the jury and other something, no new trial for new admission or something like that, which is not so important. This is how 165, up to 165 I covered. I hope that I have concluded the Indian Evidence Act completely from section 3 to 165. I hope it would be very useful for you. I wish all the aspirants of the district judge examinations to have a wonderful time and enjoy the reading and enjoy the examination also. It will be useful for you in the, not only for the examination and also for further career. Only on the basis you are going to sit and work in the district judges. I wish all of you to have a grand success in the forthcoming examination. I pray God that God will give you all sort of strength and energy, stamina and spirit for the purpose of achieving your goal. And thank you very much for this opportunity that's been rendered by Adilishmi Madam. Thank you so much, Madam, for this opportunity. I conclude my speech.
Thank you, sir. Thank you, sir. It was really excellent. And 4 sessions, and today this session was really excellent. You took us through 2.5 hours without non-stop. Then it shows the passion you have towards this particular subject of law. And I know not only this subject, you have a passion for many subjects. And Evidence Act is special to our brother Advocate Balaji, sir. Really excellent, sir. Even though this is the last session in the planned online coaching for the aspirants, it gives us, and there were so many calls for me asking me not to stop the sessions and continue the sessions. I just told them I'll definitely do it. We need a little break. Sir, we'll take a break now from you, sir, but we expect you to keep connected with Legal Eagles Alike in one form or other. Sharing your knowledge in different topics and different proposition. Even in evidence, you can take the citations or the case laws precedents as one's particular topic or any particular sections you can deliberate in depth also. We can work upon it. Thank you so much, sir. Thank you. It's a very simple word.
Thank you.
In thanking you, I thank all the faculties who have taken us through from day 1, September 23rd, Mr. Pratap started, and in fact, I told almost 18 to 19 faculties were us with this session of intensive coaching in this 1.5 months, training the civil judge and the district judge aspirants as such. And Legal Eagles Alike takes immense pleasure in thanking all the faculties, thanking all the participants, thanking all the aspirants, all the volunteers who have been connected with us. I wish every one of you, whether you are aspirant or a practicing lawyer or a law student, I wish every one of you would have taken a knowledge sharing. It was a knowledge storehouse, and it was really each one was an encyclopedia in the session. They were taking us the topics they were deliberating. So kindly keep connected with Legal Eagles Alike. Even though we are closing down this particular series, we are keeping connected with you in a different perspective. Legal Eagles Alike will be continuing with you. Balaji sir will be with you in a different topic, a different form. So for now, I take leave from every one of you. On behalf of Legal Eagles Alike and all the participants here, thank you so much, Balaji sir. We thank every one of the faculty. It was an immense pleasure traveling with every one of you. Thank you, my dear friends. Thank you, my dear volunteers. Thank you, my dear participants. Thank you, aspirants. Legal Eagles Alike wishes every one of you very, very bright future, both in your personal and your professional career. So, this session, this 100 hours intensive coaching, online coaching closes now officially. Legal Eagles Alike is opening again at 2:45 p.m. for the advocacy program on the Transgender Persons Act. It is open for all the legal fraternity to know about the law and the transgenders. The first transgender women advocate, Satyashri Sharmila, is going to be live with you to tell about her story, and it is going to be inspiration. And Kalaimamini Sudha, a transgender woman and a good friend of mine, will be with you. And this is co-hosted by Voluntary Health Services and Sri Rakta